Contact your legislator to support SB79 in Kansas. It's based on the American Laws for American Courts bill.
The American Laws for American Courts bill may soon be before your state legislature. In fact, versions of American Laws for American Courts have already been signed into law in Louisiana, in Arizona, and in Tennessee. The goal of American Laws for American Courts is simple. No U.S. citizen or legal resident should be denied the liberties, rights, and privileges guaranteed in our constitutional republic when you're involved in a legal case in a state court that considers foreign law. Now, here's what that means. If any foreign law in the particular case in dispute would deny you your constitutional rights or rights under the public policies of the state where you live, then the Constitution should overrule that foreign law. And it does, under American Laws for American Courts. But here's the problem with the current situation. Due to the legal principle of comity, respect by judges for foreign laws, there are cases in state courts where judges have ruled that foreign laws must override the Constitution. Some of these have been upheld on appeal, and that's a bad precedent. If you go to court and your case could involve a foreign law, there is a chance in these states that you could be denied your constitutional rights and your rights under state public policy, especially in divorce, child custody, and property cases. Laws from such oppressive legal systems as those of Saudi Arabia, Iran, Afghanistan, Algeria, Egypt, Gaza, Pakistan, and Syria have already been considered in American courts. This is a real risk in those states that have not passed the American Laws for American Courts bill. But a small, well-paid group of lobbyists are advocating the supremacy of foreign law, including Sharia law, over our laws. They oppose American Laws for American Courts in backroom deals, even though overwhelming majorities in state legislatures and voters support it. They pretend to support the Constitution, while insisting on the supremacy of foreign laws as the law of the land over the Constitution. Who are these groups? Well, first, the Council on American Islamic Relations, or CAIR, a branch of the Muslim Brotherhood associated with Hamas, an unindicted co-conspirator in the largest terrorism finance trial in U.S. history, with several leaders already imprisoned or deported on terrorism-related charges. Second, the Islamic Circle of North America, or ICNA, connected to Pakistan's radical Jamaat-e-Islami party, whose campaign for, quote, the greatest leaders of the last 100 years, end of quote, feature the Iranian tyrant Ayatollah Khomeini and the founding fathers of al-Qaeda, Sayyid Qutb and Abu Allah Maududi. Here are some of the deceptions these groups are spreading to attack American Laws for American Courts. Deception number 1. American Laws for American Courts is discriminatory anti-Sharia legislation, like the Oklahoma ballot initiative that was struck down as unconstitutional.
This year, they have reintroduced another anti-Sharia piece of legislation.
Now, the lawmakers have been telling us and telling the public that this law is not discriminatory, it doesn't target any religious minorities, and this doesn't limit religious freedom, that the real intent behind this law is to simply protect American laws. Now, we know that to be not the truth.
A violation of perhaps the most sacred American liberty, the freedom to practice one's faith.
That's wrong. American Laws for American Courts has no relation to the Oklahoma Amendment or similar laws and makes no mention of Sharia or any specific foreign law or legal doctrine. That's why an independent study by the Congressional Research Service found it to be constitutional, and it has never been challenged in the states where it is law. Deception number 2. American Laws for American Courts would disrupt current use of religious and foreign law for legitimate purposes, and no form of religious law could be used.
Of Lent and school districts having a high number of Catholics and serving fish on Friday, an atheist group could file a lawsuit or injunction to say that because this is based upon Christian canon law and that the Vatican is a sovereign state outside of the United States of America, they could potentially file an injunction to say that canon law is being used, which is a foreign law to American law.
That those laws or any other religious groups could not be enforced within the state of Missouri.
That's also wrong. Foreign law is respected through the time-honored principle of comity. American laws for American courts only comes into play when a legal foreign doctrine is violating someone's constitutional rights. There is no blanket ban on any foreign or religious law. The most important Muslim organization in this country, the American Islamic Leadership Coalition, has already endorsed American laws for American courts when it was introduced in Michigan, as have prominent Jewish and Christian leaders. Deception number 3. American laws for American courts would cause problems for state businesses.
And we don't want any bills such as this bill that could potentially chill companies from moving their businesses into the state of Michigan because they have fear that it would negatively affect their worker pool.
Does any business worth its salt, does international trading, works with foreign law? So if you don't allow businesses to make deals with one another using other countries' laws or using our law, then obviously business couldn't work as we know it.
American laws for American courts exempts businesses and corporations doing international business with foreign organizations, while still protecting individual constitutional rights. American laws for American courts is pro-business and encourages business to contract with foreign organizations. States with clear, specific laws on comity and foreign commerce attract businesses of all types. Deception number 4. American laws for American courts would violate a constitutional right to personal contract.
Another violation is the right to contract.
For example, a butcher would no longer be able to enforce his contract for halal meat.
Wrong again. American laws for American courts absolutely preserves the right to personally contract however you want, unless in a contractual dispute you have tried to have the state court enforce a part of the contract that voids the Constitution or state public policy. American laws for American courts would simply prevent the court from enforcing that part of the contract. Deception number 5. American laws for American courts would violate equal protection or separation of powers.
A separation of powers that the legislative branch, the one who writes laws, cannot tell the judicial branch, the judges in the courts, which laws they may or may not consider. Right? There's a separation of power. So the legislative branch cannot tell the judicial branch what laws they can or cannot consider. Another issue is unequal treatment.
Now, most states don't have a clear public policy on the issue of comity, respect for foreign law, or on choice of law. But as all lawmakers know, it is the proper role of the legislative branch of the government to make law. The judicial branch is tasked with interpreting and enforcing law. Judges are currently put in a position of having to quote-unquote make law because most states give no guidance on what to do when a foreign law is introduced in a court case. Legislatures and courts need the American Laws for American Courts bill to maintain the separation of powers. Deception number 6. Sharia and other foreign laws have never been introduced into American courts and are no threat to American laws.
In its scope, it continues to be a solution searching for a problem. There's simply no documentation of unconstitutional application of foreign law in our current judicial system.
And that these laws are unnecessary. Where in America is Sharia law being implemented by the court? And you find nowhere.
These laws are a solution in search of a problem. No one has ever suggested introducing Islamic law or Islamic principles into American courts, into the political system.
A 2011 study by the Center for Security Policy identified 50 court cases in 23 states that involved serious conflicts between the laws of 16 foreign countries and American state law. And the courts found in favor of the foreign law in 15 trial court cases and 12 appellate court cases. Meanwhile, a website dedicated to the supremacy of a kind of foreign law, Sharia law, the website's called ShariaInAmerica.com, cites 71 cases of Sharia law in American courts as precedents. Disturbingly, state court judges are incorporating foreign law into their rulings even when it conflicts with the Constitution or state public policy. So, what can Americans do to ensure that our laws are the law of the land? Our goal is for all 50 states to have a version of American laws for American courts in 5 years, by 2017, so that all Americans have due process, equal protection, freedom of religion, freedom of speech, the rights of marriage, parenthood, and personal safety under American laws for American courts. Tell your state legislator to vote for American laws for American courts in your state. Make your voice heard.